Thank you.
Hi, Miss Nurul.
Hi.
I'm calling you for this meeting. It's actually regarding to your order for our solar panels. Actually,
Yes. I've been expecting your confirmations. The installations are coming soon for those solar panels.
actually, we regret to inform that we are unable to obtain the agreed solar panels that we have been confirmed before.
I'm sorry? What do you mean you cannot obtain them? We have a contract.
Actually, there is a certain problem. Supply issues. However, we can offer you alternative models if you want.
May I ask, what are these alternative models specifications?
For this kind of specification, it actually has lower efficiency and shorter warranty period.
I'm sorry, but that's not acceptable. My customers are already expecting these specifications. I cannot tolerate any modifications.
I understand. We understand. But this is the only option that we can offer you.
No, I need the original panels as agreed. That's the whole point of this contract.
If you choose not to proceed, remember that your deposit of 125,000 ringgit will be forfeited. Gone.
That doesn't make any sense. You're the one who cannot supply those panels.
I'm so sorry. That is our policy. If you want to seek any legal advice, go ahead. I've done my part. Goodbye. Thank you.
This is going to affect all my projects. I need legal advice.
Welcome to ES Legal Chambers. My name is Swaran, junior lawyer.
My name is Jaya Prakash, can call me Jaya. I'm also junior lawyer.
Before we begin, would you like to have tea, coffee or juice?
Thank you for asking. But I'm fine now. I'm fine now.
To explain myself, I'm handling this kind of case for 5 years, such as contract, business, administration, or equity. So don't worry about your case. So before we begin, I can understand your feeling that this situation might be very stressful for your business and your reputation. So can we begin?
Yes.
Another thing, please feel comfortable to explain everything. Take your time, we are here to help you. So no worries.
So can you explain about the situation right now?
Sure. My name is Nurul. I run a business model that installs solar panel systems for residential customers. On March 2025, I entered into a written contract with Green Bolt Supplies Sdn Bhd for 400 solar panels. The panels had to meet specific output capacity and certifications standards. The agreed price was 1,250 per panel, and I paid a 25% deposit of 125,000 ringgit. 25,000.
May I know which method you use for the banking process? Did you use cash or banking?
Banking, yeah.
Did you use the online banking or retail banking?
I use
Retail banking. May I know which bank did you use for the banking process?
I think I use Blue and
Did you show about you use retail?
yes.
Okay, so may I have the receipt later after the process of our consultation?
Sure.
Yeah, could you still keeping the receipt?
I am keeping the.
And one more thing I want to clarify. Was this agreement in writing and signed by both parties?
I can assure you it's written. It's fine. Yes.
You still have the copy of the agreement?
Yes, please.
Later you can compile the agreement copy with the receipt yourself.
And try.
Just print in one file and give it to our counter.
Did the contract really specify the type and the standard of the solar panel?
Yes.
Would you say those specifications were essential for your business or reputation or for your customer?
Yes, very important.
So, we continue the question.
Okay, so did the Greenwood supply and demand contract know your customers rely on those specifications?
They do.
May I know what's the real issue in this situation?
How do I put it?
So, okay, feel free to tell us.
Okay, on the 5th of May 2025, they already informed me that they could not obtain the agreed panels. They offered a different model, which they said had lower efficiency and a shorter warranty period.
Shorter warranty period.
So if the panels were not delivered on time, it will directly affect your business.
Yes, very much.
Whether they inform of the issue and did they provide any evidence or documentation something?
We did not. They just said that to me that it is in your company's policy.
May I know which communication method they use, email or phone call?
They usually use mixed method, email, and one-to-one communication, and then
Phone call.
phone call and meeting up.
But
Right.
usually they use email, right?
Yes.
One more thing, Ms. Nurul, did they offer any competition apart from the substitute panels?
They did not.
Regarding the substitute panels, would accepting them affect your commitment for your customer?
Yes,
So it would affect your customer's reputation or your reputation.
my reputation.
So the rejecting them was necessary to protect the business.
Yes.
I understand they must have put you on a difficult position, but you should be bold and it's a good choice to meet the legal advice. I would appreciate that.
So now, regarding the deposit, the contract fee will be forfeited if you cancel the order.
Yes.
But did you cancel the order? I mean, cancel the contract?
No, I didn't.
Okay, so the issue arose because Greenwood could not perform.
Can I ask? What does that mean?
It means what the issue arrives when Greenwood is the one who cannot perform the specification or order you receive for.
I think so. From what you told me.
Ms. Nurul, based on what you have told us, there is clearly a valid contract between you and the Greenwood Supply Syndicate, right?
So their failure to supply the agreed panels amounts to a breach of contract.
Under when a contract is breached, you are entitled to claim compensation for losses caused that breach.
So in simple terms, this means you can claim for additional costs, cancel bookings, and also business losses.
Regarding your deposit money, Greenwood Supply Syndicate cannot keep it. They should refund to you.
And one more thing, they are the party who failed to perform the contract, not you, Ms. Nurul. So now, Ms. Nurul, you've got two options.
First, extend a letter of reminder requesting the refund money of 125,000 and compensation for 90,000 that you paid to them.
So starting one, if they refuse it, proceed with the legal action.
I see. So, may I ask, do I have strong case?
Yes, based on your fact that you to me, your case is very strong.
What if they say that the supply issue is beyond your control?
That argument is unlikely to succeed unless stated in the contract.
So, what should I do first?
We recommend starting with a letter of demand.
And we will now discuss your case with our senior lawyer to confirm our advice.
So, you will come tomorrow as this time to type your answer. We will discuss with the senior lawyer.
Okay.
Thanks, sir.
Take this over.
Thanks, sir.
Excuse me, please don't forget the document that I provided for, like the receipt, email, or any copy of the contract, or any recording, or any voice call, anything.
Bring whatever that would be true for us.
Later you please give that to our recipient. Goodbye, thank you, ma'am.
Thank you.
Okay, good morning, boys. Okay, sir, I don't need your breakfast. After sir, maybe after this meeting, but Joseph, Harry, we don't really need to. That's going in my business. The focus, obviously. Thank you, sir. Welcome. Okay, so now let's move on to Ms. Nurul's case. Let's slow it down and go through this case properly. Alright, I don't want any assumptions, I only want reasoning. So what's your first impression of Miss Nuru's case?
At first glance, it appears to be a straightforward breach of contract case, sir.
You see the word appears.
Sir.
That word worries me.
Sorry, sir.
Sir, the issue is whether the greenhouse failure to supply the agreed tenants constitute a breach of contract.
Good. Start from the foundation.
Thank you, sir. So there was a valid and binding contract with a specific technical specification and also a fixed delivery date, sir.
It's not fulfilling the obligation. The Greenwood company offered a substitute with a lower efficiency and a shorter warranty period than the previous one, sir.
Let's not rush to that point. So is offering a substitute automatically a breach?
Not necessarily, sir, because it depends on whether the terms is essential or not.
So in this Miss Nuru's case, is it essential?
Sir? Absolutely, sir. Because the specification go to the root of the contract, sir.
Please explain why.
Yeah, sure, sir. Because Nuru's business commitments depend on those exact specifications, sir.
And any deviation will affect the ability to fulfill the obligations to our own customers, sir.
Let me push you a bit further. Could Greenwald argue that this is just minor deviation?
They might attempt the agreement, sir.
Okay, but it would fail because the change affects performance and reliability of the panel, sir.
So we're not dealing with a trivial issue.
Really no, sir, because it goes to the root of the contract, sir.
Okay, good. So we are clear that this is just not a fundamental breach of contract.
Yes, sir.
Yes, sir.
Okay, now let's move on to damages. This is where most cases win or lose. So please convince me that she can actually recover 90,000 ringgit.
Sir, yeah. Alright, sir. Under Section 74 of the Contract Act 1950, damages are recoverable if they arise naturally from the breach or will be in the reasonable contemplation of the parties.
Okay.
The just now principle reflects as same as in the Hadley and Baxter-Hill case, sir.
So, Mr. Isran, don't just please apply the case.
Sir, the Greenwalds knew the panels were intended for scheduled installation, sir.
Okay.
So delays, additional costs, and the cancellations were foreseeable, sir.
Hold on. Are we assuming too much? Do we actually have proof that Greenwald knew the extent of Miss Nuru's business commitments?
Not direct proof of each individual contract, sir.
No, sir, but we will inform them about the installation schedule before entering the contract, sir.
Okay, so are we relying on inference?
Yes, sir. The reference supported by the communication and commercial contracts, sir.
So possibility is strong, but not absolute.
Perfect.
Okay, boys, let me challenge not whether could God say customer cancellations are too remote?
Most probably, sir, he is seen as an indirect loss.
Sir, but I would argue they are not remote, sir.
Mr. Jaya, please explain why.
Sir, because the cancellation flow directly from the failure to supply the panel, sir.
And without the panels, installations cannot be proceeded.
Okay, good. So that's a stronger argument. So now for proof, can she simply say that she lost 90,000 ringgit?
No, sir. Maybe she must do it, sir.
How?
Sir, actually, Ms. Nuru already handled all the corporate documents like invoice, contracts, and cancellation records, and also financial documents. Okay, the receptions and already have them. Yes, sir.
I just want to verify by the
Yes, sir.
This invoice are included by the copy of the original contract, sir.
Okay, that's more important. I'll go to this later. So usually courts don't accept any estimates. They usually accept result or evidence. So please remember this. Alright, sure. So now mitigation. Did this Nuru act reasonably?
Yes, sir. She serves alternative panels.
Sir, B aligns with British Edinger House Electric and Manufacturing Code and Underground Electric Lighting Code of London Limited, sir.
Okay. Could the other side argue she failed to mitigate?
Sir, they may say she should have accepted the substitute panel, sir.
And what will be your response?
Accepting inferior panels would damage your business reputation for sure, sir.
So, rejection was commercially reasonable.
Okay, good. That's a strong argument. So now let's move on to deposit. This is where disputes usually escape.
Sir, the issue is here whether video can forfeit the 125,000 ringgit.
What's the general rule here?
Deposit will be forfeited if the paying party is in breach.
And in this case,
So the Greenwood company is the one in which
so logically,
they cannot retain the deposit, I guess, sir.
from what's the authority?
Sir, Cubic Electronics in Berhad and Mass Telecommunications in Berhad, sir.
Okay, what the case? Explain it briefly, please.
Sir, it confirms that the compensation must be reasonable under Section 74 of the Contract Act 1950.
And the party in which cannot unjustly retain the deposit just like that, sir.
Exactly. So now, strategy. Do you push aggressively or just negotiate with green board suppliers?
We just begin with the letter of demand.
Why not go straight to court?
Sir, because litigation is time consuming and expensive, sir.
And the letter of demand may lead to settlement straight away, sir.
Okay, you have a point. What about negotiation?
Sir, it can resolve the dispute faster, sir.
And preserve business relationships and reputation, sir.
What's the downside of this?
Sir, the client may need to compromise on the amount, sir.
Good. Always balance recovery and practicality. Okay, so if green board ignores the letter,
Then we don't have any other option, sir. We need to proceed with the litigation, sir.
There's no option, sir.
okay, good. So now let's be realistic. What about the legal fees?
There will be professional fees and court costs, I think, sir.
Maybe some may be recoverable if she succeeds, sir.
Can she sustain the long case?
There may be a consent financial, sir.
So any settlement may be advisable for her reputation in the contract, sir.
Okay, good. That's practical advice. Okay, let's move on. What's the weakest part of the case?
Sir, the biggest part of the case is proving the exact amount of damages, sir.
Like without the perfect documentation for the loss, the claim may be reduced because the documentation for the loss she had, we cannot prove that just like that she called 90,000. So it's not that perfect, so maybe the court will argue with that.
Okay, so strong liability does not guarantee full recovery. Okay,
Yes, sir.
okay. So what's the overall assessment here?
Strong case on liability, sir.
Sir, moderate challenge in proving damages, sir.
Okay. So first, our plan is to first say a letter of demand.
Yes, sir.
Okay. Then we feedback on evidence from our part.
Sir.
Please note it down.
Yes, sir.
Third, we will be negotiating when appropriate with green board suppliers. And we will also move through litigation if really necessary.
Sir, may I ask whether the negotiation process will involve is involved as usual, sir, or not?
It depends on green board, but then technically we need Miss Ingo to be there since she is the one have an issue with the
So the negotiation process will be attended by you or with you, sir?
I have other things to work on actually. I prefer either one or the other.
Yes, sir.
Okay, then let's go for breakfast. Thank you. That's all for now.
Alright, sir. I got the people to be, Alright.
Welcome, Mr. Root. Please take a seat. Good morning, Mr. Root. Thank you for waiting. So, how's the journey here?
That was good. There was no traffic jam.
Okay, sounds good. Do you want any tea, coffee, or any breakfast?
Thank you for asking. However, I'm fine right now.
So we'll go straight to the point. Based on my review and also discussion with my junior lawyers, Green Board Supplies Sendirian Berhad has breached the contract.
And you are entitled to 125,000 of refund and damages of 90,000.
And also, Mr. Nurul, we recommend starting with the letter of demand.
So if necessary, we'll proceed with legal action. Don't worry, Mr. Nurul, we'll assist you throughout the whole process.
Thank you for providing assistance. I feel very relieved right now.
We're glad to hear that.
Sorry for interrupting, sir.
Yeah.
Here is the document that she handled just now.
It's all the bank statements, receipts, all recording.
Including the contract copy, sir.
Okay, thank you. Do you have anything else to say?
No, I do not think I have.
What about you?
No, sir. Everything you already asked during the conversation.
I think that's all I guess, Mr. Thank you for meeting us today.
You?